Okay, my name is Douglas Pinkham with Pinkham and Associates. We are a dedicated family law firm in Orange County. But this video is about the FL 341. It is a child custody and visitation order attachment. This form is attached to some other document. It's attached to a findings and order after hearing. Once you go to a hearing and then there's an order made, you can attach this to explain what the custody and visitation orders are. Or this form can be used as part of a judgment in dissolution, divorce, or a judgment for legal separation, or a judgment for paternity. And if so, then you would mark the appropriate box at the top of this form. It can also be used as part of a stipulation when you're agreeing with the other party on what the custody and visitation orders are going to be. So let's go to the top of this form. Let's go through this form. It's kind of a long form, but it's pretty self-explanatory. This form's got a lot of boxes and a lot of questions, but it's pretty straightforward. Lastly, I know that some of you can see the video or see the form on the video as we go through it, and others cannot. But there's a link at the bottom of this video. If you cannot see the video, just click on the link, print the form out, or get this form in front of you because I want you to follow along as I go line by line through this form. All right, so if you don't have the form, pause this video, get the form, come back to us. Okay, here we go. Let's start at the top of the form. Again, this is the FL 341. It's a child custody and visitation order attachment. All right. So at the top of this form, it says to, and then you're going to mark what this is attached to. Is it attached to a findings and order after hearing? Is it attached to a judgment? We're probably, if you're watching this video, you're probably using this to attach it to a judgment. Just my guess. So it might be a divorce judgment or a paternity judgment, but it's probably one of those. And you might also be attaching it as a stipulation in order for custody visitation, which would be the next one. That's an FL 355. Anyway, there's also a box for other in case it's being attached to something else, if you use it for some other issue. Anyway, let's move on. Number 1 and 2, just technical information. It's just saying jurisdiction. This court has to have jurisdiction over this case, or they can't make orders with regard to this. Common sense. Notice and opportunity to be heard is number 2. It says the responding party was given notice and an opportunity to be heard, which means an opportunity to file paperwork and or go to court, as provided by the laws of the state of California. Number 3, it says the country of habitual residence. You're going to mark the United States. If you don't, your order's not going to go through. Number 4, penalties for violating this order. If you violate this order, you may be subject to civil or criminal penalties or both. That's a standard warning that's given anytime there's custody and visitation orders made. And that's true. If you violate custody orders or visitation orders, you can be held liable criminally or civilly or both. So once there's court orders in effect for custody and visitation, you need to follow them, and it's serious. All right, 5, child custody. So that's what this whole form's about. So mark that box next to 5, and then you're going to put the child's name. Let's see, the child's name, the birth date, and then legal custody means who is legal custody going to. It's either petitioner, respondent, or joint. Then the next line is physical custody, and that is also petitioner, respondent, or joint. And then the next line would be for the next child, and so forth and so on until you have named all the children and put all the information in there. Child abduction prevention. You're only going to mark that box if there is a valid concern that you believe that the other parent is going to scoop this kid up and abduct this child. Take this child to another country, take this child to another state. If you genuinely believe that, mark that box, and then you will need to fill out an FL 341B. I have another video on that. If you need help filling out the 341B, go look for that video. All right. And by the way, that's pretty rare. You got to have some, a real belief, a real valid, reasonable belief that there's a chance for abduction. If there is, then you should fill that out and you should mark that box. All right. Visitation, number 7. This is asking about parenting time. Now, there's a lot of boxes here, but it's pretty straightforward. So if all you want to do is put an order together that says that you want the other party to have reasonable visitation, then you can mark A, and then it would be up to you two to decide later what that reasonable visitation actually is. So if you're the mother, for example, and you've got primary custody and you want to be more in control of what visitation happens down the road, you can put reasonable visitation, mark that box, and nothing else, and then it would be up to you to determine what reasonable visitation is. Or B, see attached blank page document. So it could be a 2-page document, 3-page document. You can mark B and then mark however many pages you have attached if you have something that spells out what your visitation schedule and custody schedule is going to be. Okay? Or you can mark C if the parties will go to child custody mediation or child custody recommending counseling at, and a date and time, and you put that in there. If you believe that there should be no visitation to the other party, you can mark D. Again, that's pretty rare, but if there should be no visitation to the other party, or if the court ordered no visitation, you're going to mark that box. E starts into the section where we start actually putting out a specific schedule. E says now parenting time or visitation time 4. So this is the party that's going to have this visitation time. So if dad is the respondent and he's going to have this visitation time that we're going to spell out, then you would mark respondent. And then number 1, you would mark number 1 if what you're going to spell out is certain weekends. Like he might have the 1st, 2nd, and 4th weekends. That would be marked just below there. You can see where, oops. Okay, you can see where that would be marked, say, 1st, 2nd. So say he's got 1st, 2nd, 4th weekends. You could put 1st, 2nd, and 4th weekends. And that is from, say, Friday at 6 p.m. Or you could put, not mark any of this and say it's from the start of school or after school. 2, and then you could put Sunday or whatever day it is, Sunday at, say, 6 p.m. Or it could be Friday after school to Sunday at 6 p.m. Or it could be, Tuesday, the 1st, 2nd, and 4th weeks. Anyway, it's whatever it is. Go ahead and put in there whatever it is. We could do a million different examples. Then, if you can mark 1A if you guys are going to alternate the 5th weekend of the month. You may or may not be aware that there are 4 weekends a year where they are the 5th weekend in a month. Everybody thinks it's generally common knowledge that there's a little more than 4 weeks in every month. It's about 4.3 weeks in every month. Well, that 0.3 weeks adds up, and there's 4 extra weekends a year, and they fall into one month or another. So there's 4 months out of the year that have a 5th weekend, excuse me. And you can specify who gets that 5th weekend. You can do A says the parties will alternate the 5th weekend with the petitioner having the or other party having the initial 5th weekend, which starts blah blah blah. And you put the date when the first 5th weekend starts. Typically, the 5th weekend is the weekend when people describe it as when Friday, the 5th Friday of any month, starts the 5th weekend, or if there's a 5th weekend where Saturday determines whether it's the 5th Saturday in a month. You can determine how it's determined, how it's defined. B says the petitioner, the respondent, other parent will have the 5th weekend in odd numbered months or even numbered months. They occur every 3 months, quarterly. So 2 of them are going to be in odd months, 2 are going to be in even months, just naturally. That's how it will land. So you can mark that if that's what the case is. If it's not going to be weekends done this way, you don't have to use this section. It might apply. Oh, I put that hat there. Yeah, I think you guys knew what I was getting at. All right, let's get rid of this information here. Let's go on to the next page. The next page starts out alternating weekends. So it's every other weekend. If it's going to be every other weekend, then use this section instead of the first section. So you'd mark E, alternating weekends beginning or starting on some date. So if you want it to start this weekend, put this weekend's date, Friday's date. Keep in mind, whenever you make visitation orders that include, any visitation orders must have a commencement date, or they are not enforceable. How do you say Father has every other weekend without saying which weekend that starts? 7, 8 weeks, 15 months down the road, Dad says, hey, it's my weekend. It's my every other week. And he doesn't have the kids, and Mom won't give him the kids. So he calls the police and he says, this is every other week. I've been doing every other week. And the judge and the officer says, okay, give me your court order. When does it start? Because I got to count the every other weeks to make sure this is your weekend. If there's no commencement date, there's no way to confirm that this is your weekend. So you must have a commencement date. So that's what goes in there. And then you're going to say again, from Friday at 6, Sunday at 6, or from after school on Friday until Sunday at 8 p.m. or whatever it might be. Fill it in that way. If you're also going to have weekday visits, they could be every Wednesday overnight. They could be Tuesdays and Thursdays from after school until 6 p.m. Or they could be every Wednesday for a dinner visit from 5 o'clock until 8 o'clock, whatever it is. If there's going to be a weekday visitation, mark that under 3, and then commencing, again, you need that commencement date, so make sure you have the commencement date in there, and then specify what that visitation is going to be in the section below there. If there's some other visitation schedule or restrictions or parenting plan that you want to list, you can list it in 4 underneath this section. If you need more space, it specifically says, take another piece of paper, list at the top attachment 7E4. You may also use form MC 025. It's just a declaration form or a blank form that you can use to spell out what this is at. If you mark that it's listed in this attachment and you mark that box, you're golden. Just attach it. All right. Libby, can you get that? It's line 2. All right. All right, that's that section. All right, let's move on to 8. 8 is supervised visitation. If the court ordered visitation, supervised visitation, or if you guys are agreeing to supervised visitation, you're going to mark this box, and you're going to specify the information, the relevant information in here. So it's going to say supervised visitation until a date or until further order of the court, whatever it is. And then it's going to be for the petitioner or the respondent. Who is it that has monitored visits? Is it Dad that has to be monitored? Then you're going to put whether he's the petitioner or the respondent, and then you're going to put his name in there. Okay, and then if this is the case and you've marked supervised visitation, you are absolutely going to also need to attach an FL 341A. I have another video on the 341A. Consult that video when you're filling out that form. And then attach it to this before it gets filed. All right. So again, supervised visitation, it's pretty rare unless the court ordered it. Let's go on to 9, transportation for visitations or parenting plan. All right. So what is this referring to? It's referring to who's going to pick up the kid or who's going to drop off the kids for visitation during the visitation. So let's say standard, by the way, standard transportation orders are that the receiving parent picks up the children. That's just generally what we do. Why do we do that? Because if you're the receiving parent, you're probably going to be on time. You're probably going to be more willing to collect your kids. If you have to give the kids back and you have to travel to drop the kids off at the other parent's house, or if you have to travel even halfway and some meeting point in the middle, you're less likely to be there on time. You don't have as much incentive to be on time or even to show up sometimes. So it's very common to have the receiving parent pick up. B says transportation to begin the visits to be provided by petitioner or respondent or some other person, and you would specify who that is. C is transportation from the visits, that's at the end of the visit, will be provided by petitioner, respondent, or other. Specify. D, the exchange point at the beginning of the visitation will be at a certain address. So if it's at a police department, that's fine. If it's at, by the way, that's not fine. Kids know that there's some major problem if you have a visitation exchange that occurs at a police department. If you can and you're meeting somewhere to do this, meet at a McDonald's. Meet at some public place where there's always video. Then you can make it a fun thing. You can get a Happy Meal for the kidders or whatever. Police departments are ugly places to have a custody exchange. Just keep that in mind. So you're going to put the address where the meeting place at the beginning, and E is a meeting place, the address for the meeting place at the end of the visit. F says during the exchanges, the party driving the children will wait in the car, and the other party will wait in his car or her home or exchange location while the children go between the car and the home or the car and the McDonald's or wherever it is. You're only going to want to mark F if the parents aren't getting along and they can't co-parent very well, and you're very concerned that there's going to be arguments or altercations or whatever. So F is, again, that's ugly. You don't want to have to mark that unless it's absolutely necessary or unless a court ordered it. G is other, anything else that fits into this category. If you want to write it in there, you can. Under this particular category, I could probably come up with an infinite number of different things that could be put in other, but we won't get into that. If you need something, write it in there. Okay, 10, travel with the children. So this is limiting a parent from traveling any certain distance. So let's say, for example, you want both parties to not be able to leave the state of California with the children without getting a court order or something. You can put petitioner and respondent must have written permission from the other party or a court order to remove the children from A, state of California. Or you might have, just the respondent is not allowed to remove the children from, Shasta and Redding County areas. Or Orange and San Bernardino and Riverside and LA, whatever. Or C, you could get even more specific, or say the 7 Southern California counties or something to that effect. But if there's restrictions, this is where you would mark that, and you would mark it for the petitioner or the respondent or both or whatever. All right, page number 3. Page number 3 at the top, again, you're going to put the petitioner's name, respondent's name, and the case number. Below that is box 11. So if you want a holiday schedule, mark that box and then mark is attached in the attached schedule. Then I'm going to have you fill out an FL341C. It's a very detailed form regarding holidays, and I've got a video that helps you figure out how to fill that out. It's in the judgment section of this thing, but look for that 341C. That'll help you out. And people fill that form out incorrectly every single time, so get my advice before you fill out that form. Okay, 12 additional custodial provisions. If you're going to mark that box, as well as any of these on this page, by the way, there's another form that goes with it. So if there's other additional custodial provisions that you want one party or the other to follow, then mark 12, and then you're going to mark in the attached schedule, and then use the 341D, the FL341D. Again, I got a video on that, so review that video before you submit it. And then any of these forms that you're filling out in addition, you're going to attach it to this form before this form gets filed. Legal custody, number 13. You're positively going to want to attach, you're going to want to mark that positively. Anytime you get kids, you need legal custody orders. And you're definitely going to want to attach the 341E, the FL341E. So go get help on that form. So definitely mark 13, definitely mark in the attached schedule, and definitely go fill out an FL341E. And consult my video when you fill that out. All right, then number 14, mark that box. It's automatic. In the state of California, there's a family code section. 3025 says that both parents, even a non-custodial parent, has equal rights to information about the child, schooling, medical, those kinds of things. So it's standard California law, but definitely mark that box so that there's no confusion down the road that, you know, dad or mom or both of you have equal access to school records or medical records or whatever they may be. All right, and then 15, other. If there's something else that has to do with custody visitation, scheduling, you know, whatever, transportation, some restrictions, this is a good section, other, to put that in if it doesn't already fit somewhere else on here. Okay, and that is this entire form. That's the form. It does not require a signature. It's not signed under penalty of perjury. It's just a form that gets attached to a judgment or something else, as you know. And then again, there could be other forms like the 341E, the legal custody schedule. That is attached to this form. So those are attached to this form, and then this form is attached to a judgment or an order after hearing. But anyway, that is this form. That completes the FL341. I hope this video was helpful for you. Again, this is a form that you're definitely going to be used with a judgment or an order after hearing. So if you have kidders, so I hope this video was helpful. Thank you very much.